I walked into that conference room thinking I knew what was coming. 23 years with the same company, and suddenly no agenda, no warning, just a calendar invite that said quick chat, 3 p.m. This story is inspired by real-life submissions. The moment I saw their faces, I understood. This wasn't a meeting. This was an execution. Janet from HR sat with her hands folded like she was about to deliver bad news to a child. My manager, Derek, wouldn't make eye contact. And there, dead center on that polished table, was a document I hadn't been asked to review. A severance agreement? Already printed? Already dated. "Thanks for coming in," Janet said, her voice dripping with that false warmth people use when they've rehearsed. "We wanted to talk about your future here. My future." As if I still had one. Derek cleared his throat. "We know this year has been overwhelming for you. Overwhelming. I'd hit every metric. Trained half the department. Covered for 3 people during the summer when everyone was out sick. But I'm 64. And apparently, that's all they saw. We're offering you 2 options," Janet continued, sliding the paper closer. "You can request a voluntary separation leave on your own terms. With Dignior, we can proceed with a performance review process that, frankly, won't end well for anyone." There it was. The trap. Sign now and pretend it was my idea. Or refuse and get dragged through a public humiliation designed to make an example out of me. I looked at the document. The letterhead. The signature line already highlighted in yellow. They wanted me to choose which kind of shame I preferred. But here's what they didn't expect. I noticed the clock. Derek kept glancing at his watch. Janet's leg bounced under the table. There was a rhythm to their impatience, a desperate energy that didn't match the calm cruelty of their words. They were in a hurry, and people in a hurry want you to sign before you think. So I did the one thing abusers hate most. "I'd like this in writing," I said. "Everything you just told me, documented, notarized." The room temperature dropped. Janet's smile flickered. We've already provided the document, not this," I interrupted, tapping the severance packet. "I want the reasoning, the performance concerns, the timeline, all of it, official and on record." Derek shifted. "That's not really how, because," I continued, keeping my voice steady, "I helped draft the employee handbook update back in 2019, the one that revised termination protocols for staff over 60. Section 12, subsection C. The one that ties severance to pension vesting and Medicare bridge coverage. I let that sit. I'm assuming you reviewed that clause before calling me in here?" Janet's eyes flicked to Derek. Derek's jaw tightened. "That clause is still in effect, isn't it?" I asked. Silence. The kind of silence that tells you someone just realized they're standing on ice. We're just trying to make this easier for you," Janet finally said, but her voice had lost its edge. "Then putting it in writing shouldn't be a problem." I stood, picked up my copy of the document they'd printed too, which told me they expected me to sign on the spot. I folded it carefully and slipped it into my bag. "I'll have my attorney review this and get back to you." "Your attorney?" Derek's voice cracked just a little. "Yes, you understand." I walked out of that room with my head high and my hands steady, even though my heart was pounding so hard I thought they could hear it. But as I passed the receptionist's desk, I caught something. A post-it note on Derek's folder. Half hidden, but I saw it. "Branch audit Gen 15. Close all legacy before then. January 15th. That was 11 days away. They weren't just trying to get rid of me. They were racing a deadline. And whatever they were hiding, it was bigger than just one 64-year-old woman who wouldn't stay quiet. I sat in my car for 20 minutes before I could turn the key. My hands were shaking, not from fear, from rage, the kind that burns clean and cold. 23 years. I'd given them 2 decades of my life, and they'd boiled it down to a 10-minute ambush and a highlighted signature line. But that post-it note kept flashing in my mind. Branch audit Jan 15. Why would a routine employee separation need to happen before an audit? I drove to the bank branch near my house, not the one by the office, somewhere I could think. I needed to withdraw some cash, but mostly I needed to sit somewhere that wasn't home. Wasn't work, wasn't anywhere that felt like the ground was shifting under me. While I was waiting in line, my phone buzzed. A text from Marissa. She was one of the younger women in our department, maybe 32, sharp as hell. Are you okay? Derek just told everyone you decided to pursue other opportunities. Said it was your choice. My choice. I typed back, we need to talk. Not here, not on work devices. Her response came fast. Coffee? Tomorrow morning? Yes. I pocketed the phone and tried to focus. But my mind was spinning. If they were already telling people I'd chosen to leave, they were betting I'd sign. Betting I wouldn't fight. Betting I was too old, too tired, too grateful just to have made it this far. When I got home, I went straight to the filing cabinet in my office, the one I'd been meaning to organize for years. I pulled out the folder labeled Work Important. Inside were copies of every major policy update I'd helped write or review. Performance reviews going back 15 years. Emails I'd printed because something felt off and I wanted a record. I'm not paranoid. I'm just someone who's seen enough corporate misunderstandings to know that paper trails matter. And there it was. The 2019 Employee Retention and Benefits Amendment. 17 pages. Single-spaced. Signed by the VP of HR and the regional director. I flipped to section 12. Employees aged 60 or above with 20 years of continuous service are entitled to full pension vesting and Medicare bridge coverage in the event of company-initiated separation. Voluntary resignation waives these protections unless explicitly stated otherwise in writing. My stomach dropped. If I signed that severance agreement as a voluntary separation, I'd be waiving protections worth tens of thousands of dollars, protections I'd earned, and they knew it. They were counting on me not reading the fine print, counting on me being overwhelmed, counting on me to trust that after 23 years, they wouldn't screw me over. I pulled out the severance packet and read it again, slowly this time. The language was slippery. It called my departure voluntary, but listed performance concerns in the appendix, concerns I'd never been formally written up for. Concerns that, conveniently, would justify bypassing those protections if I challenged it later. It was a trap within a trap. My phone buzzed again. This time, it was a call from a number I didn't recognize. I almost didn't answer, but something told me to pick up. Hello, hi, is this? A pause. A woman's voice, hesitant. Is this the woman who worked with Derek Paulson? Who's asking? My name's Lauren. I used to work in your department. I left last April. Lauren. I remembered her. Quiet. Competent. One day she was there. The next, she wasn't. They'd said she'd decided to spend more time with family. They told me you left voluntarily, I said carefully. She laughed, but it wasn't a happy sound. Is that what they're saying about you, too? My pulse kicked up. What happened to you, Lauren? Same thing that's happening to you, she said. They called me in. No warning. Told me I had two choices. Sign or get fired with cause. I was 58. My husband had just been diagnosed with Parkinson's. I couldn't risk losing our health insurance. So you signed. I signed, she whispered. And I lost everything. The pension bridge. The Medicare gap coverage. Everything I thought I'd earned. They told me it didn't apply because I'd chosen to leave. I closed my eyes. Did you have a lawyer look at it? By the time I realized what I'd signed, it was too late. They said I'd waived my right to dispute it. Lauren, I said slowly, did they rush you? Did they make you sign the same day? Silence. Then, yes. They said if I didn't sign by 5 p.m., the offer would be rescinded and I'd be terminated for cause the next morning. There it was. The pattern? Do you still have any of the paperwork? I asked. I think so. Why? Because, I said, my voice steadier than I felt. I think they've done this before. And I think they're about to do it again. What are you going to do? I looked at the folder in front of me. The policy they'd hoped I'd forgotten. The protections they'd tried to bury. I'm going to make them put it in writing, I said. Every word. I didn't sleep that night. Every time I closed my eyes, I saw Janet's rehearsed smile. Derek's watch. That post-it note with the audit date. By 6 a.m., I was already dressed and looking up employment attorneys on the State Bar website. I needed someone who specialized in age discrimination. Someone who'd seen this before. Someone who wouldn't tell me to just take the money and walk away. I found a name, Patricia Alvarez. 20 years in employment law. Her bio mentioned multiple cases involving corporate retaliation and forced resignations. I called her office the second they opened. Law offices of Patricia Alvarez. Hi, I need to speak with someone about a severance agreement. They're trying to make me sign it, and I think something's wrong. The receptionist's voice softened. How soon do they want you to sign? They wanted it yesterday. Hold, please. 2 minutes later, a calm, steady voice came on the line. This is Patricia. Tell me what happened. I told her everything. The ambush meeting. The 2 options. The clause I'd helped write. The post-it note. Lauren's story. When I finished, there was a pause. How old are you? She asked. 64. And how long have you been with the company? 23 years? Bring everything you have, she said. I can see you this afternoon at 2. Don't sign anything. Don't communicate with them except in writing. And if they call, let it go to voicemail. Her office was in a quiet building downtown, the kind with plaques by the door listing decades-old law firms. It felt solid, reliable. Patricia was maybe 50, with sharp eyes and the kind of posture that said she didn't waste time. She spread my documents across her desk, the severance packet, the 2019 policy, my printed emails, Lauren's contact information. She read in silence for 10 minutes. Then she looked up. They're trying to screw you, she said flatly. And they're doing it in a way that makes it look like you had a choice. Can they do that? Legally? No. Ethically? Absolutely not. Practically. She tapped the severance agreement. They do it all the time. Especially to women over 60. They bet you won't fight. They bet you'll be too embarrassed, too tired, or too scared of losing what little they're offering. I'm not signing, I said. Good. Because this. She held up the agreement. This is coercion. And if we can prove they used age as a factor which, based on what you've told me, they absolutely did this, becomes an ADEA violation. What's ADEA? Age Discrimination in Employment Act. Federal law. If they terminated you or forced you out because of your age, and they did it to avoid paying benefits you're entitled to, that's illegal. She pulled out a yellow pad and started writing, I need you to request your full personnel file. Every performance review. Every email that mentions you. Every policy document related to terminations and benefits. Will they give me that? They have to. It's your right under state law. And here's the thing, she leaned forward. When you make that request, it puts them on notice. They'll know you're not just walking away. They'll know someone's watching. What if they retaliate? Then we add retaliation to the complaint. Her voice was ice cold. But here's what I think is really going on. You said there's an audit coming. January 15th. And they're rushing to close legacy cases before then. She tapped her pen against the desk. That tells me they're cleaning house. Getting rid of expensive employees before someone external looks at the books? Expensive because we're old? Expensive because you have benefits they don't want to pay. Pensions? Health coverage? Protections they wrote into contracts years ago and now regret. She pulled up something on her computer. I'm going to send you a template for requesting your files. You'll submit it through their HR portal today. We'll also send a separate letter to their legal department, preserving your rights under the 2019 policy. What will that do? It'll make them sweat, she said. Because right now, they think you're just one woman who got her feelings hurt. They don't know you kept the receipts. I felt something loosen in my chest. Not relief, not yet, but something close to hope. One more thing, Patricia said, her voice softer now. This is going to get uncomfortable. They're going to try to make you feel like you're overreacting, like you're being difficult, like you should just be grateful for what they offered. I know. Do you? She held my gaze. Because I've seen this 100 times. Women like you, smart, capable, professional who've spent their whole careers being reasonable. And when you finally stand up for yourself, they act like you've lost your mind. I thought about Janet's smile, Derek's condescension, the way they'd spoken to me like I was a child who couldn't understand her own paperwork. I'm ready, I said. Patricia nodded. Then let's make them put it in writing. I submitted the records request that night from my kitchen table. My hands were steadier this time. Within an hour, I got an auto reply confirming receipt. Within 2 hours, my phone rang. Derek's number? I let it go to voicemail, just like Patricia said. He didn't leave a message. But 20 minutes later, Janet from HR sent an email. Hi, just wanted to check in and see if you had any questions about the transition package. We're happy to walk you through anything that felt unclear. Would love to chat soon. The exclamation points made my skin crawl. I forwarded it to Patricia without responding. Her reply came back in under a minute. They're scared? Good. I stared at that email for a long time. They're scared. Not me. Them. The next morning, I met Marissa at a coffee shop 3 towns over. Somewhere no one from work would accidentally walk in. She was already there when I arrived, sitting in the back corner with 2 cups in front of her. She looked nervous. I ordered you a latte, she said. I hope that's okay. It's perfect. Thank you. She waited until I sat down, then leaned in. What's really going on? I told her. Not everything, not the lawyer, not the records request, but enough. The ambush meeting. The severance packet. The rush to sign. Her face went pale. They told us you were retiring early, that you wanted to spend more time with family. I don't have family nearby, I said quietly. My daughter's in Seattle. My son's in Colorado. They know that. Marissa's jaw tightened. They're lying. Yes. She stared into her coffee. Last month, they did the same thing to Robert. He was 61. One day he's there, the next day he's gone. They said he wasn't adapting to new systems. But Robert built half those systems. Did he fight it? No, he just disappeared. I tried to reach out, but his work email was deactivated the same day. His LinkedIn says he's pursuing consulting opportunities, but I don't think that's true. I pulled out my phone and opened the Notes app. Do you remember exactly what Derek said? About me? She nodded slowly. He called a team meeting yesterday afternoon. Said you'd decided to pursue other opportunities and that we should all be supportive of your choice. Then he said she hesitated. Say it. He said, at her age, sometimes people just get overwhelmed. It's natural. There it was again. My age. Used like a weapon. Marissa, I need you to do something for me, I said. And I need you to be careful. Okay? If Derek or Janet or anyone from HR asks you about me, I need you to tell them I seemed fine. That you had no concerns about my performance? Can you do that? Of course. But why? Because they're going to try to build a case that I was struggling, that I needed to go. And I need people who'll tell the truth if it comes to that. She reached across the table and squeezed my hand. I'll do it. And if you need anything else, just ask. That afternoon, I got an email notification from the HR portal. Your personnel file request has been processed. Documents will be available for review within 10 business days per company policy. 10 business days. That would push it past the audit date. I forwarded it to Patricia. Her response was immediate. Unacceptable. State law requires 5 business days. I'm sending a formal demand. An hour later, I received another email. This one from an address I didn't recognize. legal@company.com. Dear Ms. Brennan, we've received your request for personnel records. In the interest of efficiency, we'd like to schedule a time to discuss your transition and address any concerns you may have. Please let us know your availability this week. Best regards, Michael Torres, Associate General Counsel. I read it 3 times. They'd escalated to legal. That meant they were taking this seriously. Or they were trying to control the narrative before it got out of hand. I called Patricia. They want to meet, I said. Of course they do. They want to feel you out. See if you're really going to fight or if you're just making noise. What should I do? Tell them all communication goes through me. Then forward me the email. I typed out a response. Kept it short. Please direct all inquiries to my attorney, Patricia Alvarez. I CC'd Patricia and hit send. My heart was pounding. Within minutes, my phone rang. A number I didn't recognize. I didn't answer. It rang again. Then again. Finally, a voicemail appeared. I played it on speaker so I could hear it clearly. Hi, this is Michael Torres from the company legal team. I just wanted to reach out personally to let you know we're committed to resolving this amicably. I understand there may have been some miscommunication, and we'd really like to clear that up before things become more formal. Please give me a call when you get a chance. Again, we're here to help. His voice was smooth, practiced, the kind of tone that made help sound like a threat. I saved the voicemail and sent it to Patricia. Her response was one word. Perfect. That night, I couldn't stop thinking about what Marissa had said. At her age, sometimes people just get overwhelmed. I pulled out my laptop and opened my email archive. I searched for every performance review, every commendation, every thank you I'd received over the years. There were dozens. Outstanding leadership during Q3 transition, exceeded expectations in client retention, mentored junior staff with exceptional skill and patience. I printed every single one. Then I went further back. I found the email thread from 2019 when they'd asked me to help revise the employee handbook, the one that included the clause protecting employees over 60. In that thread, the VP of HR had written, "We want to make sure our senior staff feel valued and protected. This policy reflects our commitment to that." I printed it. Then I found something else. An email from 3 months ago. Derek had forwarded me a company-wide memo about streamlining operations and reducing overhead. I hadn't thought much of it at the time. But now, reading it again, I saw the phrase buried in the 3rd paragraph. Legacy cost structures will be reviewed and adjusted as needed. Legacy cost structures. That's what they called us. People who'd been there long enough to earn real benefits. People who cost more than the 25-year-olds they could hire for half the salary. We weren't employees. We were line items they wanted to erase. I printed that email too. Then I sat at my kitchen table, surrounded by paper, and realized something. They'd made a mistake. They'd assumed I wouldn't look, wouldn't ask questions, wouldn't fight back. They'd assumed that at 64, I'd be too tired, too scared, or too grateful to make trouble. But they'd forgotten something. I was the one who'd taught half that department how to document everything, how to keep records, how to build a case. And I'd just built one against them. Patricia's formal demand letter went out the next morning. I didn't see it before she sent it. She said it was better that way. Less chance of me second-guessing myself. But I felt it the moment it landed. My phone started ringing at 10:47 a.m. Michael Torres again. Then Janet. Then a number with a New York area code I didn't recognize. I ignored them all. By noon, I had 4 voicemails and 6 emails, all with the same tone, concerned, friendly, eager to help. Patricia called me at 12:30. They're panicking. How can you tell? Because they've already responded to my letter. Usually, corporate legal takes 3 to 5 days to acknowledge receipt. They wrote back in 2 hours. What did they say? They want to meet. Tomorrow. They're offering to fly someone in from regional. They're also offering to clarify the severance terms and correct any misunderstandings. My stomach twisted. That sounds good, doesn't it? It sounds like they know they screwed up, Patricia said. And now they're trying to fix it before it becomes a formal complaint. So what do? We take the meeting, but we do it on our terms. My office, everything recorded. And they bring every document related to your employment, your benefits, and any communication about your termination. Will they agree to that? They already did. That afternoon, I finally listened to the voicemails. Michael Torres, smooth as ever. We'd really love to sit down and talk through this. I think there's been a misunderstanding about the timeline and the benefits package. We want to make sure you're taken care of. Janet, trying to sound warm. I feel terrible that you're upset. That was never our intention. Can we please just talk? I think we can work this out. And then the third one. A woman's voice I didn't recognize. Hi, my name is Carol Dietrich. I got your number from Lauren Pritchard. She said you might be going through something similar to what I went through last year. I sat down. I worked for the same company. Accounting department. I was 62 when they called me in and told me I had performance issues I'd never heard about before. They gave me a severance offer and said I had 24 hours to decide. I signed because I was scared. But I lost my pension bridge and my health coverage gap, and now I'm working part-time at a grocery store just to keep my insurance until Medicare kicks in. Her voice cracked. I didn't know I could fight it. I didn't know it was illegal. But if you're fighting, I want to help. I still have the paperwork. And I have a voicemail from HR where they told me I needed to sign before end of business or the offer would be rescinded. If that helps, it's yours. I saved the message and immediately called her back. She answered on the first ring. Carol, yes, is this? It's me. Thank you for calling. She let out a breath. I didn't know if I should. Lauren said you were standing up to them. And I couldn't let you do it alone. How many of us are there? I asked. I don't know. But I know of at least 3 others in the last 18 months. All women. All over 60. All pushed out the same way. My hands were shaking. Carol, would you be willing to talk to my attorney? Yes, absolutely. Whatever you need. I called Patricia immediately and told her about Carol. And about the others. There was a long pause on the other end. This isn't just about you anymore, Patricia said quietly. This is a pattern. And if we can prove it, this goes from a single severance dispute to a class action. What does that mean? It means they're not just facing one employee with a complaint. They're facing a federal investigation. It means the Department of Labor gets involved. It means audits, penalties, and public exposure. Will they settle? They'll try. But here's the thing, you have to decide what you want. Do you want your benefits back and a quiet resolution? Or do you want them held accountable for what they did to all of you? I thought about Lauren, struggling to care for her husband. Carol, working at a grocery store at 63. Robert, who just disappeared. I want them held accountable, I said. Then we need every piece of evidence we can get. Emails, voicemails, documents, witnesses, anything that shows this was intentional and targeted. I'll get it. That night, I called Lauren. I heard from Carol, I said. She called you. Good. I wasn't sure if she would. How did you find her? I didn't, Lauren said. She found me. About 6 months after I left, she reached out through LinkedIn. Said she'd heard what happened to me and wanted to know if it was true. And you told her? I told her everything. And she told me her story. And then we started wondering how many others there were. Do you know any names? A few. But most people don't want to talk about it. They're embarrassed. Or scared. Or they've just moved on and don't want to relive it. I understood that. The shame of it. The feeling that maybe you were too old, too slow, too much. Lauren, I said carefully, would you be willing to testify? If it came to that? Silence. Then, quietly, my husband's getting worse. I can't afford to lose what little stability we have left. I know. I'm not asking you to risk anything. I just need to know if you'd be willing to tell the truth if someone asked. Another pause. Then, yes. If it helps stop them from doing this to someone else, yes. The meeting was set for the next day at 2 p.m. I barely slept. I kept thinking about what Patricia had said. You have to decide what you want. I wanted my benefits. I wanted my dignity. I wanted an apology. But more than that, I wanted them to know they couldn't do this anymore. Not to me. Not to anyone. I arrived at Patricia's office 15 minutes early. She was already there, laying out documents on the conference table like a surgeon preparing for an operation. How are you feeling? She asked. Terrified. Good, that means you care. She looked at me. Remembered you don't have to say anything in this meeting. I'll do the talking. You're just there as a witness to your own story. At exactly 2 p.m., they arrived. Michael Torres, corporate legal. A woman I didn't recognize, senior VP of HR, apparently. And Derek. Derek looked like he wanted to be anywhere else. Patricia didn't offer coffee. Didn't make small talk. Just gestured to the chairs and hit record on her device. Let's begin, she said. And I realized, sitting there across from the people who'd tried to erase me, that the power had shifted. They weren't here to tell me what to do. They were here to explain themselves. Michael Torres opened with a smile that didn't reach his eyes. First, let me say we deeply regret any confusion or distress this situation has caused. That was never our intent. Patricia didn't blink. What was your intent? He hesitated. We were trying to facilitate a smooth transition that worked for everyone. By giving my client 2 hours to sign a severance agreement that waived tens of thousands of dollars in earned benefits? That wasn't, he glanced at the HRVP. That wasn't how it was supposed to be presented. Then how was it supposed to be presented? Patricia slid a document across the table. Because this agreement clearly states voluntary separation, but the meeting notes my client took indicate she was told to either resign or face termination for cause. The HRVP, her nameplate read Susan Kellerman, shifted in her seat. I think there may have been a miscommunication. A miscommunication, Patricia repeated. Let me ask you this. How many employees over the age of 60 have been separated from the company in the last 18 months? Silence. I'll rephrase, Patricia continued. How many employees over 60 have voluntarily left the company since January of last year? Michael Torres cleared his throat. I don't have those numbers in front of me. That's fine. I do. Patricia pulled out another document. 7 employees. All women. All between the ages of 58 and 64. All with tenure exceeding 15 years. All separated within weeks of company audits or benefits reviews. She let that sink in. Would you like to explain that pattern? Susan leaned forward. We've been undergoing organizational restructuring. That's not uncommon, and indeed that restructuring specifically target your most senior, most expensive employees. The ones with protected benefits under policies your company drafted and signed? We didn't target anyone, Susan said, but her voice had lost its confidence. Patricia turned to Derek. Mr. Paulson, did you tell other employees that my client was overwhelmed due to her age? Derek's face went red. I may have said something to that effect. And did you tell my client that she had 2 options? Resign voluntarily or be terminated for performance issues? I was trying to give her a choice. A choice between two forms of humiliation is not a choice, Patricia said coldly. It's coercion. She pulled out another document. This is a voicemail left for Carol Dietrich, another former employee, in which your HR department stated she had until end of business day to sign or the offer would be rescinded and she'd face immediate termination. She played it. A man's voice, clipped and professional. Carol, this is Brian from HR. Just following up on our conversation. We really need your signature by 5 p.m. today. After that, we'll have to move forward with alternative measures. I hope you understand we're trying to help you here. The room went cold. That voicemail, Patricia said, was left for a 62-year-old woman whose husband had just been diagnosed with a terminal illness. She signed within an hour because she couldn't afford to lose her health insurance. She lost her pension bridge anyway because your severance agreement classified her departure as voluntary. Michael Torres's jaw tightened. We're prepared to discuss a revised offer. I'm sure you are, Patricia cut in. Because you know that if this becomes a formal EEOC complaint, you're not just facing one case. You're facing a pattern and practice investigation. And when the Department of Labor starts looking at your termination records, they're going to find a lot more than 7 women. Susan's hands were folded so tightly her knuckles were white. What do you want? That's not the question, Patricia said. The question is, what are you willing to do to make this right? After they left, I sat in Patricia's office for a long time, trying to process what had just happened. They're going to settle, Patricia said. They have to. How do you know? Because they brought Derek. That was a mistake. He's a liability. He said things in that meeting that confirm coercion and age discrimination. If this goes to court, he'll be the star witness for our side. What happens now? They'll come back with an offer. Probably within 48 hours. And it'll be better than the first one. But here's what you need to prepare for. They're going to ask you to sign a non-disclosure agreement. Meaning I can't talk about it. Meaning you can't talk about it. Can't warn others. Can't tell anyone what they did. You take the money, you restore your benefits, and you stay quiet. I stared at her. What if I don't want to stay quiet? Then we don't settle. We file a formal complaint. We go public. And we make sure every woman they pushed out knows she has a case. But that takes time. Months. Maybe years. And it's brutal. Depositions. Lawyers trying to tear apart your credibility. They'll dig into every mistake you ever made at work, every bad review, every sick day. They'll try to make it look like you were a problem employee who deserved to be let go. Even though I wasn't. Even though you weren't, she said gently. That's how they fight. They make it so exhausting, so invasive, that most people give up. I thought about Lauren. About Carol. About all the women who'd signed because they were too scared, too tired, too worn down to fight. What would you do? I asked. Patricia looked at me for a long moment. I can't tell you what to do. But I can tell you this. Every woman who settles quietly thinks she's protecting herself. And maybe she is. But she's also protecting them. Because as long as this stays hidden, they keep doing it. That night, I got a call from a number I didn't recognize. I almost didn't answer. But something made me pick up. Hello? Is this the woman who's suing the company? The voice was young, female, nervous. I'm not suing anyone, I said carefully. Who is this? I work in payroll. I shouldn't be calling you. But she paused. I processed your severance agreement. And I've processed a lot of them. And they're all the same. Older women. Same language. Same rushed timeline. My heart started pounding. What's your name? I can't tell you that. But I wanted you to know there's a file. An internal file. It's called Legacy Workforce Transition. It has names, ages, salaries, benefit costs, and there are notes. Strategy notes on how to encourage voluntary separation for employees over 60. Do you have access to that file? Not anymore. They locked it down last week. right after you requested your personnel records. Why are you telling me this? She was quiet for a moment. Then, because my mom is 63, and she works for a company just like this one, and I don't want this to happen to her. The line went dead. I sat there, phone in hand, staring at nothing. They had a file, a strategy. This wasn't a few bad managers making mistakes. This was policy. I called Patricia and told her everything. When I finished, she didn't say anything for a long time. Then, if that file exists and we can prove it, this isn't just about you anymore. This is a federal case, and they'll do anything to keep it buried. What do I do? You decide, she said. Do you want justice, or do you want peace? I closed my eyes. 23 years, 7 women, a file with our names on it. I want them to stop, I said. Then we don't settle, Patricia said. We fight. The offer came exactly 43 hours later. An email from Michael Torres. Professional, polite, carefully worded. They were prepared to restore my full benefits under the 2019 policy. Retroactive pension vesting, Medicare bridge coverage, full health care continuation, a cash settlement for emotional distress and inconvenience that was triple the original severance offer. And one other thing, a confidentiality agreement that prohibited me from discussing the terms of separation, the circumstances leading to separation, or any internal company matters with anyone outside my immediate legal counsel. I forwarded it to Patricia without responding. She called me 10 minutes later. It's a good offer, she said. Financially, it's more than we'd likely get, even if we won in court. But it comes with a muzzle. You take this, and Lauren never gets her benefits back. Carol keeps working at that grocery store. And the next woman they target won't know this happened because you won't be allowed to tell her. I stared at the email on my screen. The numbers were real. The security was real. How long do I have to decide? They want an answer by end of business tomorrow. Of course they did. Always the rush. Always the pressure. What if I say no? I asked. Then we file a formal complaint with the EEOC. We request that legacy workforce transition file through discovery. We subpoena records. We build the case that this was systematic age discrimination. And that takes how long? 6 months minimum before we even get to a hearing. Maybe longer. Can I afford that? She was quiet. Financially? Probably not. Emotionally? That's what you need to figure out. I called Lauren that night. They made an offer. I said, that's good news, isn't it? They want me to sign an NDA? If I take it, I can't talk about what happened. I can't help you get your benefits back. I can't warn anyone else. Silence on the other end. Lauren, take it, she said quietly. What? Take the money. Get your benefits. You earned them. You don't owe us anything. But I mean it. Her voice cracked. You have a chance to be okay? Don't throw that away because of what happened to me. I made my choice. I signed. That's on me. It's not on you. They manipulated you. And they'll manipulate the next person, and the one after that. You can't save everyone. Sometimes you just have to save yourself. I wanted to argue, wanted to tell her she was wrong, but I could hear the exhaustion in her voice, the weight of caring for a dying husband, the reality of living on Social Security at 60. She'd been fighting for years, just to survive. Who was I to ask her to fight more? I didn't sleep that night. I kept thinking about that file. Legacy workforce transition. Our names in a spreadsheet. Our salaries calculated. Our benefits marked as costs to reduce. I thought about the anonymous caller from payroll. I don't want this to happen to my mom. I thought about Patricia's question. Do you want justice? Or do you want peace? At 3 a.m, I got up and made coffee. Sat at my kitchen table with all the documents spread out in front of me. Performance reviews going back 20 years. commendations, thank you notes from clients. The 2019 policy I'd helped draft. Proof that I'd been good at my job. Proof that I'd earned everything they tried to take away. And then I pulled out one more document. The original severance agreement. The one they'd wanted me to sign in 2 hours. I read it again, slowly. There was a section I'd skimmed before. Legal language about arbitration and waiver of rights. But buried in the middle was a clause I'd missed. Employee acknowledges that no unlawful discrimination occurred and waives any claim under federal or state civil rights law. They weren't just buying my silence. They were buying my testimony. If I signed, I couldn't help anyone else. Even if I wanted to. Even if subpoenaed. I'd be legally barred from saying discrimination happened. Because I'd have signed a document saying it didn't. At 8 a.m., I called Patricia. I need you to send them a counteroffer, I said. What are your terms? I want my benefits restored. I want the cash settlement. But I won't sign an NDA that prevents me from responding to legal inquiries or government investigations. They'll never go for that. Then we filed a complaint. Patricia was quiet for a moment. You're sure? I'm sure. This is going to get ugly. It already is ugly, I said. I'm just done pretending it's not. The response came back in 4 hours. Not from Michael Torres. From someone higher up. Regional VP of Legal Operations. They rejected the counteroffer, but they also did something I didn't expect. They withdrew the original termination. Effective immediately, I was being reinstated as an active employee. Full benefits restored. Back pay issued. Personnel file amended to remove all reference to voluntary separation. They were giving me my job back. Patricia called me the moment she saw it. Do you understand what this means? They're trying to make the problem go away. No. They're trying to make you go away. If you're an active employee, you can't file a wrongful termination claim. You can't argue you were discriminated against because you weren't actually terminated. But what about Lauren? Carol, the others? They're still out. And unless they file their own complaints, there's nothing you can do for them as an active employee. I felt the trap closing. If I accepted reinstatement, I got everything back. But I lost the standing to fight for anyone else. If I refused and pushed forward with the complaint, I'd be unemployed, fighting a company with unlimited legal resources for months or years. What do I do? I asked. Patricia's voice was careful. I can't make this decision for you. But I can tell you if you take reinstatement, they win. Not because you didn't fight, but because they've structured it so that fighting means losing everything. That's not fair. No, she said. It's not. I sat in my car outside Patricia's office, staring at the email on my phone. They'd reinstated me. Restored everything, made me whole. And in doing so, they'd made sure I couldn't help anyone else. I thought about Lauren's words. Sometimes you just have to save yourself. I thought about Carol's voicemail. If you're fighting, I want to help. I thought about that anonymous caller. I don't want this to happen to my mom. And I thought about the next woman. The one who'd walk into a conference room 6 months from now and see a severance agreement already printed, already dated, who'd be told she had 2 choices, who'd be rushed and pressured and made to feel like she was the problem. I opened my contacts and called Patricia. I'm not taking reinstatement, I said. Are you sure? I'm not doing this for me anymore, I said. I'm doing it so the next person doesn't have to. There was a long pause. Then Patricia said quietly, okay? Then let's make sure they never forget your name. The formal complaint was filed with the EEOC on a Tuesday morning. Patricia walked me through every page before we submitted it. 37 pages documenting everything. The ambush meeting, the coerced severance, the pattern of terminations, the 2019 policy they'd violated, Carol's voicemail, the anonymous tip about the internal file. Once this goes in, Patricia said, there's no taking it back. They'll know you're serious. And they'll fight. Let them. She hit submit. Within 6 hours, my phone started ringing. Not from the company, from a journalist, Ms. Brennan. This is Ashley Chun from the Tribune. I'm working on a story about age discrimination in corporate America. And I heard you filed a complaint against your former employer. Would you be willing to talk? I looked at Patricia. She nodded. Yes, I said. I'll talk. The article ran 4 days later. Front page of the business section. When experience becomes expendable. Age discrimination cases rise as companies cut legacy costs. They didn't name the company, not yet. But they named me, and they told my story. The morning it published, my phone didn't stop. Messages from former colleagues. I had no idea. That's what happened to you? I'm so sorry. Messages from strangers. This happened to my mother. Thank you for speaking up. You're not alone. And one message from a name I recognized. Robert. The man Marissa had mentioned. The one who'd pursued consulting opportunities. I read the article. They did the same thing to me. I signed because I didn't think I had a choice. If you're building a case, I want in. I forwarded it to Patricia. Her response, that's 3. We need 5 to make it a class action. 2 days later, I got a certified letter. Not from the company, from their law firm. A big one? The kind with offices in 12 countries? It was a cease and desist. They claimed I'd violated confidentiality by speaking to the press, that I'd made false and defamatory statements about the company, that I was causing irreparable harm to their reputation and business operations. They demanded I retract the article, issue a public apology, and agree to binding arbitration, or they'd sue me for breach of contract and defamation. I called Patricia, my hands shaking. They're bluffing, she said immediately. How do you know? Because you never signed their confidentiality agreement. You never signed anything. They're trying to scare you into backing down. It's working. I know. That's the point. But here's what they don't know. I sent a copy of their cease and desist to the Tribune. And the journalist is very interested in the fact that they're trying to silence you for telling the truth. The follow-up article ran 3 days later. Company threatens legal action against whistleblower in age discrimination case. This time, they named the company, and this time, it went viral. Within 24 hours, the story was picked up by national outlets, business networks, employment law blogs. LinkedIn was on fire with people sharing their own stories. And then the emails started coming, not just from former employees of my company, from employees at other companies, other industries, other states, all with the same story. Called into a meeting with no warning. Severance agreement already printed. Told to sign today or face termination. Lost benefits. Lost dignity. Stayed quiet because they were ashamed. Patricia's inbox was flooded. We have 23 people who want to join the complaint, she told me. 23 women, all over 60, all pushed out the same way. What does that mean? It means this isn't just about your company anymore. This is about an industry-wide practice. And the EEOC is paying attention. The company tried to control the damage. They issued a statement. Professional, polished, completely empty. We are committed to fostering a diverse and inclusive workplace where employees of all ages are valued. We take these allegations seriously and are conducting a thorough internal review. An internal review. By the same people who'd created the legacy workforce transition file. But the damage was done. Their stock dropped 2%. Small, but enough to get the board's attention. And then something unexpected happened. An executive from their competitor reached out. Not to me, to Patricia. They wanted to talk. Off the record, Patricia took the meeting and called me afterward. They have the same file, she said. Different name, they call it workforce optimization, but same strategy. Same targets. They want to settle with their people before this becomes a trend. Why are they telling you this? Because they'd rather fix it quietly than get caught publicly. And because they're smart enough to see where this is going. Where is it going? Federal investigation, new regulations, congressional hearings. Maybe this is bigger than you now. You started something. I sat with that for a long time. I'd just wanted my benefits back. I'd just wanted them to stop. But somehow, telling the truth had cracked something open. 3 weeks after the article ran, I got a call from the Department of Labor. They were opening a formal investigation into my former employer. They wanted to interview me, along with anyone else who'd been affected. I gave them Carol's number, Lauren's, Robert's, and the 23 others who'd come forward. The investigator, a woman named Diana Reeves, was calm and methodical. I want you to understand, she said. This is going to take time. Months, maybe longer. They'll fight us on every document request, every deposition, every subpoena. I know. And they're going to come after you. They'll try to discredit you. Make you look like a disgruntled employee with an axe to grind. I know that too. Then why are you doing this? I thought about that anonymous caller from payroll. About her 63-year-old mother. Because someone has to, I said. Diana nodded slowly. For what it's worth, I've been doing this job for 15 years. I've seen a lot of people give up. A lot of people take the money and walk away. You're not one of them. I don't feel brave. Brave people never do, she said. They just keep showing up. That night, I got an email from an address I didn't recognize. No subject line, just a message. The file you're looking for is stored on a secure server. Access logs are backed up off-site. If subpoenaed, they can't delete it without leaving evidence. Someone needed to know that. No signature. No way to trace it. But I forwarded it to Patricia immediately. Her response came in seconds. Game changer. The subpoena for the legacy workforce transition file went out on a Friday. Patricia warned me it would take weeks to get a response. Corporate legal teams dragged everything out as long as possible. But the response came in 4 days. Not with the file. With a motion to quash the subpoena, claiming the documents were privileged attorney-client work product and proprietary business strategy. Patricia wasn't surprised. They're protecting it. Which means it exists, and it's damaging. Can they just refuse to hand it over? They can try. But the judge will decide. And if the judge orders production and they still refuse, that's contempt. That's sanctions. That's a headline that says they're hiding evidence. The hearing was set for 2 weeks out. In the meantime, the Department of Labor investigation was moving forward. Diana Reeves and her team were methodical, interviewing every woman who'd come forward. Cross-referencing termination dates, severance amounts, benefits lost. They found the pattern immediately. Every woman over 60. Every woman with tenure over 15 years. Every woman pushed out within 90 days of an audit or benefits review. And the language in the severance agreements was nearly identical across all of them. This isn't coincidence, Diana told Patricia. This is systematic. And that means someone at the top approved it. 5 days before the hearing, I got a call from Susan Kellerman, the senior VP of HR, the woman who'd sat in Patricia's office and claimed everything was a miscommunication. I'd like to speak with you, she said, privately, off the record. I don't do off the record anymore. Please, just hear me out. I conferenced Patricia in without telling Susan. I'm listening, I said. Susan's voice was tight. This has gotten out of hand. The board is furious. Legal is furious. And frankly, I'm the one taking the fall for decisions I didn't make. What decisions? The file? The strategy? I didn't create it. I inherited it when I took this role 3 years ago. It was already in place, already being implemented, and you went along with it. She paused. I should have questioned it. I should have pushed back. But I didn't, and that's on me. But the people who designed this system, the ones who decided that older employees were too expensive, they're still there. And they're letting me take the blame. Why are you telling me this? Because if that file becomes public, it's not just going to hurt the company. It's going to hurt people like me, people who were just doing what they were told. And I'm asking you, one woman to another, to consider a settlement before this destroys everyone. Patricia's text came through immediately. Do not respond. Let me handle this. Susan, I said carefully, I appreciate you calling. But this stopped being about me a long time ago. What do you want? Her voice cracked. Money? A public apology? I can make that happen. I want the truth, I said. I want accountability, and I want it to stop. It will stop. We're already changing policies after you got caught. After 23 women came forward, after the Department of Labor started investigating. That's not accountability. That's damage control. Silence. I'm sorry, Susan said quietly. I really am. Then testify, I said. Tell the truth about who created that file and why. Help us make sure this never happens again. She hung up. The hearing was in a federal courthouse downtown. Patricia and I arrived early, took seats in the back of the courtroom. The company's legal team showed up with 6 attorneys, all men, all expensive suits. The judge, a woman in her late 50s named Caroline Porter, reviewed the motions with a kind of precision that made everyone sit up straighter. Counselor, she said, addressing the lead attorney for the company, you're arguing this file is privileged work product? Yes, Your Honor. It contains strategic business communications prepared in anticipation of litigation. When was the file created? He hesitated. We'd need to review the metadata to confirm you don't know when it was created. But you're claiming it was prepared in anticipation of litigation. We believe. I'm not interested in what you believe. I'm interested in facts. She turned to Patricia. Ms. Alvarez, do you have evidence suggesting this file predates any litigation? Patricia stood. Yes. Your Honor, we have testimony from a former employee indicating the file was created and actively used for workforce planning as early as 2022. No litigation was filed until this year. Judge Porter looked back at the company's attorney. So this wasn't prepared in anticipation of litigation. This was business as usual. Your Honor, even if that's true, the file contains proprietary information about how to systematically terminate older employees. The judge's voice was ice. I'm not inclined to protect that as proprietary. She made her ruling on the spot. Motion to quash is denied. The file will be produced within 10 business days, with appropriate redactions for legitimately privileged material only. If you fail to comply, I'll hold your client in contempt. She banged the gavel. It was over in 12 minutes. Patricia and I walked out of the courthouse into cold February air. We won, I said, still trying to process it. We won this round, Patricia corrected. But they're going to appeal. And even if they don't, they'll drag out production as long as they can. But we'll get the file. We'll get the file. I felt something I hadn't felt in months. Not relief. Not quite. But something close to vindication. The file arrived 9 days later. 247 pages. Spreadsheets with names, ages, salaries, and benefit costs. Termination timelines, color-coded by risk level. Strategy memos discussing optimal separation windows and cost mitigation through voluntary resignations. And at the top of one memo, dated January 2022, a subject line that made my stomach turn. Phase 3. Legacy workforce reduction targeting high-cost senior employees. It wasn't just a file. It was a blueprint. Patricia sent it to Diana Reeves at the Department of Labor. Her response came within the hour. This is worse than I thought. We're escalating. 2 days later, the company made a final offer. Not to me, to all of us. Full restoration of benefits for every woman who'd been affected. Back pay. Compensation for lost pension contributions. A formal apology. Policy changes with third-party oversight. And no NDA. They know they can't win, Patricia said. The file is public record now. The Department of Labor has it. The EEOC has it. They can't bury this anymore. What do the others want to do? I asked. Most want to settle. They're exhausted. They need closure. And you? What do you think I should do? She looked at me for a long time. I think you've done enough. You fought when no one else would. You exposed a system that was designed to stay hidden. You gave 23 women their power back. But only you can decide if that's enough. I thought about Lauren, about Carol, about Robert, about all the others who'd been too afraid or too tired to fight. They'd get their benefits back. They'd get compensation. But the executives who'd created that file, they'd still have their jobs, still have their bonuses, still be free to do this again, somewhere else, to someone else. I want them held accountable, I said. Not just the company. The people who made the decisions. Patricia nodded slowly. Then we don't settle. We go to trial. And we name names. The settlement offer sat on my kitchen table for 3 days. Numbers that would change my life. Security I'd spent 23 years earning. Benefits restored. Dignity acknowledged. All I had to do was sign. But every time I picked up the pen, I thought about that file. Phase 3. Legacy workforce reduction. Someone had written that. Someone had approved it. Someone had looked at women like me, women who'd given decades to a company and decided we were just numbers to eliminate. On the 4th day, I called Patricia. I'm not signing, I said. You're sure? I'm sure. But I need you to do something for me first. What? Set up a call with everyone. Lauren, Carol, Robert, all 23. I need to talk to them before we move forward. The call happened that night. 26 people on a Zoom. Faces I'd never seen. Voices I'd only heard over the phone. Patricia muted herself and let me speak. I know most of you want to settle. I started, and I understand why. This has been exhausting and painful, and you deserve closure. The company's offer is fair. You'll get your benefits back. You'll be made whole. I paused. But here's what won't happen if we settle now. The executives who created that file won't face consequences. The VP who signed off on Phase 3 will keep his job. The HR directors who implemented the strategy will get promotions. And in 5 years, at another company, they'll do this again. Silence. If we go to trial, it's going to be hard. They'll dig into our lives. They'll try to make us look incompetent, bitter, difficult. They'll drag this out as long as they can. I looked at the screen, at all those faces. So, I'm not asking you to fight. I'm asking you to vote. Because this is your story too. And whatever we decide together. Lauren spoke first, her voice quiet but steady. I thought I was done fighting. But if there's a chance to make sure this doesn't happen to someone else's daughter, someone else's mother, I'll fight. Carol was next. I'm in. I've spent a year being angry at myself for signing. Maybe it's time to be angry at the right people. One by one, they spoke. Robert, Marissa, who'd quit in solidarity. 3 women I'd never met. By the end, 21 out of 23 voted to move forward. The 2 who wanted to settle, Patricia arranged individual agreements for them. No judgment, no pressure. But the rest of us? We were going to trial. The trial was set for 8 months later. In the meantime, the story kept growing. Congressional hearings were scheduled on age discrimination in corporate America. The EEOC issued new guidelines on coerced resignations. 3 other companies settled similar cases quietly, changing their policies before they got sued. Our case became the case everyone was watching. And the company knew it. 1 week before trial, They made a final offer. Not a settlement, a capitulation. Full benefits restoration for everyone. A $10 million fund for back pay and damages. A formal public apology. Termination of the executors who'd created and implemented the legacy workforce program. Third-party oversight of all future terminations. And no confidentiality requirement. Patricia called me the moment the offer came through. "They're giving you everything," she said. "Everything you asked for. What's the catch? No admission of wrongful intent. They'll say it was poor judgment and inadequate oversight, but they won't admit it was illegal." I closed my eyes. So they still get to save face. Partially, but those executors are out. The policies are changing. And every woman who was hurt gets compensated. That's real accountability, even if it's not perfect. What do you think I should do? "I think you've already won," she said. "The question is whether you can live with a win that's not total." I thought about that for a long time. Total victory would mean a verdict. A judge saying, on the record, that what they did was illegal. Punitive damages, criminal referrals, maybe. But it would also mean another year of depositions. Another year of my life consumed by this fight. Another year of watching them try to destroy my credibility. And it wouldn't change the outcome for the women who'd already gotten their benefits back. I called Patricia. "I'll take the offer," I said. "But I want one more thing." "What?" "I want to be there when they make the public apology. And I want to speak." She was quiet for a moment. "I'll make it happen." The press conference was held on a Tuesday morning in the company's main headquarters. They'd wanted to do it quietly, in a written statement. But Patricia insisted public apology meant public. The interim CEO, a man I'd never met, read from prepared remarks. Talked about learning from mistakes and commitment to improvement and valuing employees of all ages. It was polished, sanitized, forgettable. Then Patricia introduced me. I walked to the podium, looked at the cameras, at the journalists, at the company representatives sitting in the front row trying not to squirm. "My name is Catherine Brennan," I said. "I'm 64 years old. And a year ago, I was told I had two choices: resign with dignity or be fired with cause." I let that sink in. I didn't choose either. I chose a third option. I chose to tell the truth. I talked about the file, the pattern, the 23 women who'd come forward, the system that had been designed to make us disappear quietly. This wasn't a mistake, I said. This was a strategy. And the only reason it's changing is because we refuse to stay silent. I looked directly at the interim CEO. To every woman who's sitting in a conference room right now, being told she's overwhelmed or not keeping up, or that she should consider her options, you're not the problem. And you're not alone. I stepped back from the podium. The room was completely silent. Then, from the back, someone started clapping. A journalist. Then another. Then more. It wasn't polite applause. It was the kind that says, "We see you." 3 months later, I got a letter. From the anonymous caller, the woman in payroll who'd tipped me off about the file. She didn't sign her name, but she told me this. Her mother had just been promoted at her company. Not pushed out, promoted. And when HR had suggested transitioning senior staff to consulting roles, her mother had asked to see the policy in writing, asked about her benefits, asked about age discrimination protections, and they'd backed down. "Because of you," the letter said. Because she knew she could. I keep that letter in my desk drawer. On the hard days when I wonder if it was worth it, if I should have just taken the first offer and walked away, I pull it out and read it. Because here's what I learned. Sometimes the system isn't designed to give you justice. It's designed to make you accept injustice quietly. And the only way to change that is to refuse. Not with violence. Not with cruelty. But with the simple, stubborn act of telling the truth. I spent 23 years building something at that company. And in the end, They tried to erase me like I'd never existed. But I didn't let them. I walked out with my name intact, my benefits restored, my dignity earned. And I left the door open for the next woman who needs to know she doesn't have to choose between two kinds of shame. There's always a third door. You just have to be brave enough to find it. If you're watching this from somewhere quiet, somewhere you feel unseen, tell me in the comments where you are. And if you've ever faced something like this, know that someone out there is listening. You're not alone. And you're not too old to fight back.